He was 53 years old. He had never been arrested, not once. He paid his taxes. He voted in every election since he was 21. He taught his granddaughter how to throw a football in the front yard every Saturday morning. He never broke the law. He thought the law was on his side. He thought the law was the reason he was safe. Then one Tuesday morning on his way to work, a pair of headlights flicked on behind him. He pulled into a parking lot because the rules of the road say you should. He rolled down his window because that is what people do. He handed over his license and registration because he had been taught to cooperate. He answered the questions because he believed refusals were the kind of thing guilty people did. Then the officer asked to search his phone. He said yes because he thought it was the polite thing to do. He thought it was the legal thing to do. He thought the officer had a reason. He thought he had nothing to hide, so why fight it? What the officer did not tell him, what no one ever told him, was that everything he had just agreed to had been rewritten by the Supreme Court of the United States 3 days earlier in a 7-2 ruling on June 29th that sent shockwaves through every courthouse in America. By the time the officer walked back to the patrol car with that phone in his hand, the man had already given up more rights in 10 minutes than most lawyers knew he still had. Now he is the one paying for it. And the thing that should keep you up tonight is that this was not about that man being guilty. That man was not guilty. He was never charged. He was never accused of anything before the search started. He was just an ordinary American who did exactly what almost every American has been taught to do his entire life. He was the victim of a ruling that most people have not heard about, do not understand, and are not prepared for. This is the video you needed before you ever turn your key in the ignition again. Stay with me. Subscribe to this channel right now, not as a favor, but because the next 90 seconds of legal information might be the only thing standing between you and a situation you cannot walk back from. We cover the rulings the news will not explain, the rules the system will not tell you, and the exact steps you need to take to make sure your rights are still your rights when it matters. Do not wait to need this information. Put it in your head now. Here is what happened on June 29th. The Supreme Court handed down a 7-2 decision that did 3 things at the same time. It expanded what police may do during a routine traffic stop without ever asking a judge for permission. It narrowed the definition of what counts as a legal reason to search your belongings. And it created a brand new category of consent that you can give without ever saying yes out loud. That last part is the part that should frighten you, because most Americans believe consent requires words. Most Americans believe that until you say yes, you have not agreed to anything. The new ruling tells police that consent can be inferred. It can be implied. It can be reconstructed from your body language, your tone, your failure to object within a certain number of seconds, or even the simple act of handing something over when asked. Now, let me say this clearly. The majority of the court did not write this as a permission slip for police abuse. They wrote it as a clarification of how consent works in the real world. They said officers in the field cannot be expected to conduct a constitutional seminar before every search. And they said a person who hands over a phone, opens a trunk, or unlocks a glove compartment has, in the court's view, communicated something. The dissent, the 2 justices who broke from the majority, wrote the opposite. They said the ruling puts a burden on the citizen that the Constitution was specifically written to protect against. They said this is exactly the kind of silent erosion the Fourth Amendment was designed to stop. They said that ordinary people do not know what consent means in court, and they should not have to know because the Constitution is supposed to be a shield for the people who do not know, not just the people who have lawyers on speed dial. This is the collision. On one side, you have your daily life, your car, your phone, your house, your family's information, your private texts, your medical records, your financial passwords. On the other side, you have a system that just expanded the legal definition of when those things can be reached for, opened, and reviewed, without ever needing to walk into a courthouse and ask a judge for a piece of paper. The clash is not abstract. The clash is the next time you drive to work, The clash is the next time a stranger in a uniform taps on your window. The clash is the next time you reach for your registration because your father told you that is what you do. Let me make this personal for a second. Where I sit right now, I am looking at a phone. You are looking at a phone. We all are. That phone contains the most complete map of your private life ever assembled in human history. It knows where you sleep. It knows where you worship. It knows the name of the doctor you saw last month. It knows the exact words you typed to your spouse at 2 in the morning. It knows what you searched when you were scared. It knows your passwords. It knows your kids' school schedules. Before June 29th, the rule was that an officer needed a piece of paper signed by a judge before that map of your life could be opened. After June 29th, that piece of paper is no longer the only path. That is the ruling. That is what 7 to 2 means in your life. Now, let me walk you through the part the news will not tell you. Let me walk you through the trapdoor. Most people who hear about this ruling will assume it cannot hurt them. They will say, I am a good person. I do not break the law. I have nothing to hide. This affects criminals. This affects people who are doing something wrong. That is exactly the kind of thinking the ruling rewards, and it is exactly the kind of thinking that gets good people destroyed. Here is the trapdoor in plain English. The rights this ruling is talking about do not just protect the guilty. They protect everybody. The Fourth Amendment, the part of the Constitution that says the government cannot search you or take your stuff without a good reason, was written for the citizen who never expected to need it. That is the entire point of having rights. You do not write them for the people who already know they are in trouble. You write them for the people who never thought they would be. The minute you are pulled over, the minute a stranger asks you a question with a badge on, you are no longer the safe citizen in your living room. You are a person inside a legal process. Every word you say, every nod you give, every silence you allow, every document you hand over has now entered that process. And here is what the ruling quietly confirmed that most people will miss. The standard is not whether you are guilty. The standard is whether you agreed. The system does not need to prove you did anything wrong before looking through your phone. The system only needs to argue that you gave consent. Once they argue that, the burden often shifts onto you to prove you did not. That is how ordinary people lose. Not because they broke the law, because they failed to understand that the conversation they thought was a polite exchange was actually the moment they gave up their constitutional shield. If you hear only one thing from this entire video, hear this. The single biggest mistake Americans make during police encounters is treating them like conversations. They are not conversations. They are legal events. Every syllable is being recorded, sometimes on body camera, sometimes on dash camera, and sometimes by the officer's own memory in a sworn statement written hours later after he has had time to choose the words that help his case. You cannot unsay a thing. You cannot unnod. You cannot unhand over your phone. This is why what comes next matters so much. Here is the survival protocol. This is what you do. This is what you say. This is what you never say. Memorize it. Practice it in your bedroom tonight. Teach it to your spouse, teach it to your teenager, teach it to the senior citizen in your family who still believes the officer is always right. This is the difference between leaving a traffic stop as the person who walks back to their car and leaving a traffic stop as the person whose life is now being investigated. When the lights come on behind you, you slow down, you signal, you pull into a safe, well-lit spot, you put your hands on the wheel, you do not reach for anything until the officer approaches, you roll down the window just enough to speak and pass documents. You keep the engine running unless you are told otherwise. These are not legal tricks. These are safety moves that also protect you legally because they show you were not afraid, you were not fleeing, and you were not fumbling for a reason. When the officer asks for your license, registration, and proof of insurance, you provide them. That is a legal obligation in every state. You are required to identify yourself. You are required to show documents when asked. Do not argue this point. Do not withhold this point. This is where you are required to cooperate, and cooperation here is not weakness. When the officer asks you where you are coming from, or where you are going, or whether you know how fast you are going. You give the shortest, truest answer you can. You can say, I am coming from home. You can say, I am going to work. You can say, I believe I was driving the speed limit, but I understand your observation. You do not elaborate. You do not volunteer opinions. You do not explain your day. Every extra sentence is a thread the officer can pull later. When the officer asks to search your car, you say, I do not consent to a search. That is the full sentence. You do not say, why do you want to search it? You do not say, I have nothing to hide. You do not say, go ahead. You say the short, plain refusal. You say it once. You say it calmly. You say it the same way every time, so it is the only version of the moment the officer can write down. When the officer asks for your phone, you say, I do not consent to a search of my phone. You do not unlock it. You do not place it on the dashboard. You do not say, sure, here it is. You hold it. You keep it on your person or in your closed bag. You repeat the short refusal if you are asked again. Your phone is not a glove compartment. Your phone is not a paper document. Your phone is the most private space you own, and the law in Chas, even after this ruling, still treats it differently. The Supreme Court did not change that. Do not change it for them. When the officer tells you to step out of the vehicle, you step out. The Supreme Court has long held that an officer may order a driver out of a car during a traffic stop. That is not a moment to argue. That is a moment to comply calmly so you can continue protecting everything you still have the right to protect. When the officer asks you to sign something, you do not sign it on the spot. You say, I want to read this. You take your time. You ask what each line means. You do not let urgency become the reason you lose a right. If the document is a citation, you sign only after you have read it. If the document is a consent form, you refuse to sign it, and you say so in plain words that the camera can hear. When the officer tells you that refusing will lead to arrest, that refusing will lead to further steps, that refusing will make things worse for you, you do not panic. You repeat your refusal in the same calm words. You understand that the officer is allowed to apply pressure. The officer is allowed to threaten. That pressure is part of the encounter, and it is not a reason to give up your rights. Pressure is the language of legal events, not the language of conversations. When you are released, you write everything down. The time, the location, the weather, the officer's name and badge number if you could see it, the exact words the officer used, the exact words you used. You write it down before you talk to anyone else because memory fades, and the only defense you will have later is the record you kept that night. Then and only then you call a lawyer, not a friend, not a family member, a lawyer. If you cannot afford one, you say, I cannot afford an attorney. You insist. You do not answer detailed questions until your lawyer is on the phone or in the room. That is not suspicious behavior. That is the legal behavior the system was built to support. This protocol is not about being hostile. It is not about being difficult. It is not about disrespect. It is about understanding something the ruling made painfully clear. The system will treat cooperation as consent. The system will record your words, your movements, and your silences as evidence. The system will be polite, professional, and absolutely serious about using everything you give it. If you do not match that seriousness on your side, you will lose, and you will lose even if you were right. Now, let me close this the way I started it. The man at the beginning of this video was 53 years old. He was not guilty. He was not charged. He was not dangerous. He was just an American who believed the rules would protect him because he had always followed them. He did not know the rules had changed. He did not know the very act of helping, of being polite, of answering, of handing things over, had been folded into the new legal definition of consent. He did not know that the law had moved from protecting the citizen from the search to protecting the officer from the accusation of searching without permission. That shift is real. It happened on June 29th. It was decided 7-2 Two justices saw it clearly enough to write the dissent that future courts will quote when this ruling begins to do the damage it was written to do. You now know something most Americans will not hear on the news tonight. You know the ruling, you know the trap door, you know the protocol, you know the exact words to say and the exact silence to keep. You know that your phone is a different thing than your glove compartment. You know that consent is not a conversation you stumble into. You know that pressure is part of the event, not a reason to fold. That knowledge is yours now. It is not theoretical. It is not optional. It is the kind of knowledge that takes 10 minutes to learn and that one morning on a road you have driven 1,000 times to need. Carry it with you. Practice it tonight. Teach it to the people who would not survive a single bad answer. That is what this channel is for. Stay safe. Stay alert. Stay informed. And come back tomorrow because there is another ruling, another change, and another chapter in the long story of what it means to be a citizen in a country where the rules keep moving under your feet.